One of the things about estate planning is that you should always appoint somebody to act as your guardian in case you ever get disabled. So, for example, one of my clients came to me and said her brother was, basically they found him disabled and they didn't know what to do with him. And her brother didn't have a spouse or no kids to take care of him, and so the sister basically had to take care of him. But there was no documents. So what we end up having to do is go to court. It's called a guardianship or a living probate. And we go to court and we try to appoint her. And it sounds easy, but it really isn't, because we have to make sure he's actually disabled. So the judge actually hires another attorney who interviews him and goes through the medical records and makes sure he's actually disabled. So what happened with this client, this happened 2 years ago. The guardianship process took 1.5 years. They spent a lot of money on attorney's fees, and it finally ended in a trial, and he was adjudicated, or he was determined disabled, and my client, the sister, is now the guardian. The gentleman is only 57 years old. He is an alcoholic, and so he has issues with dementia. And so this will go on for many, many years, and that's the sad part about guardianships. Every year we have to file something with the court, and the judge has to approve everything that goes in and out of his accounts, and the sister, my client, has to take care of that every year. So not only are we spending money on the upfront and trying to get her appointed, but every year we're going to spend more money to make sure that it's actually properly administered. So that is the tragedy of not appointing somebody. It's very important to have documents that state who's going to be your guardian in case you ever get disabled.
Okay, so you can go, like, just kind of clarifying it, but like, how can you avoid that situation?
How to avoid it is really having your papers prepared while you're still competent and able to do it. So you prepare powers of attorney. That's key and very simple to do. And then the second step is actually getting your affairs in order through a will or a living trust. And if you get disabled, then your trustee will also act on your behalf. So.
Is there a certain age that maybe you would suggest to start doing this stuff?
Mm-hmm. There really is no certain age. Any one of us can be hit by a bus or any one of us can get disabled, and that's
Sure.
the sad thing. So I always tell people the earlier the better. It's sort of similar to insurance.
Yeah.
You never know when you're going to get disabled, and you don't know when you're going to pass away. And then it's too late because you didn't buy the disability insurance or the life insurance. Similarly, if you don't write the documents now before the disability actually happens, we go through this court process that I just explained.